Ladies and gentlemen, it is so nice to be here. My name is Rhett, DeHart. I'm a lawyer, a partner in Adams and Reese in Charleston. I'm a graduate of this law school many years ago, and I'm honored to moderate this panel. We got three outstanding guests, and I'm going to introduce them in different orders. The first is Judy Martinez to my immediate right. Judy is the president of the World Justice Project and the former president of the American Bar Association. She has served on the chair of the ABA Standing Committee on the Federal Judiciary and as a member of the Task Force on Building Public Trust in the American Judicial System. Judy is currently a partner at Simon Perigine in New Orleans, and prior to that, she was the vice president and Chief Compliance Officer at Northrop Grumman, one of America's largest and most respected defense contractors. Judy, I really still wish you were Chief of Compliance at Northrop Grumman. You'd be my new best friend, but it's a great company. And Judy graduated from Tulane Law School in New Orleans with honors. Judy, we want to thank you for traveling here. As I told you, my wife and my in-laws and my law firm is all based in New Orleans. I get there a lot, but for you all don't know, it's there's no direct flights from New Orleans to most of South Carolina. I know it was a long travel day, so thank you so much for being with us. To Judy's right is Professor Scott Bauries. Professor Bauries joined the University of South Carolina School of Law in 2022. He was previously a law professor at the University of Kentucky for 14 years. His scholarship here at the RiceSchool of Law focuses on judicial decision-making in state and federal constitutional cases, and he's here today to share with us his work on judicial selection in all 50 of our states. At the RiceSchool of Law, Professor Bauries teaches constitutional law, federal courts, conflicts of law, and civil procedure. Professor Bauries graduated #1 in his law school class at the University of Florida, and afterwards he clerked on the 11th Circuit Court of Appeals for Judge Emmett Cox. Last but not least, to my left is Stephanie Radcliff. Stephanie is a second-year student here at the University of South Carolina School of Law. She received her undergraduate degree from the University of California, Los Angeles, UCLA, with a BA in economics and a minor in Asian languages. As a member of the South Carolina Law Review's editorial staff, Stephanie's work on the South Carolina court reform was recently selected for publication and participation in this symposium. Her article discusses the history of judicial selection in South Carolina and focuses on whether recent reforms sufficiently addressed these concerns. Her article further considers how judicial recusal in South Carolina over this perceived conflict of interest plays out in practice. I must say, Stephanie, your note was quite timely given the recent judicial reforms in South Carolina. I don't know if that was coordinated or not, but congratulations on your scholarship. So I think we're going to make this as casual as possible. If anybody has any questions at any time, feel free to interject. We want to make it as casual as possible. But I'm going to put the professor on the hot seat first. Professor,
all right.
Give us a brief overview of the different judicial selection methods that are most common in state courts in South Carolina, nationally.
Nationally, yeah. Thank you very much. I appreciate being part of this, and I appreciate the just holding this symposium at all is a really important topic. I would break the judicial selection and retention methods in the 50 states down into 4 different basic methodologies, each of which has some variations within the category. So one I would call the federal model, and this is the least common among the states. There's only 4 states that do this, but I would define the federal model the way our federal model works. Appointment of the judge by an executive, the governor, and then either life tenure or some defined tenure of some length that safeguards judicial independence over time. This model is the first model that was used to deviate from the original colonial model or the original founding era model. Some of the states at the time of the founding had this model, very few. Most of them had a model that's closer to what we have here in South Carolina, which I'll get into in a second. The second group we might refer to as the democratic model of selecting judges. And this involves popular election of judges, and there's a number of different ways that this can occur. About eight states have partisan judicial elections. In other words, judges run for office periodically as Republicans or Democrats or independents or Green Party candidates or whatever it is, and they get elected on a party basis, and usually have to wade through a party primary, a partisan party primary, in order to become a candidate for the ballot. That's 8 states. 13 states have a similar process, but their elections are nonpartisan, meaning that it is unlawful to identify yourself as a party member as a candidate for the office of judge in those states. So it's still popular election, and there are still campaigns, and there are still the same issues that are related to campaigns, like campaign finance, those sorts of things, but not on a partisan basis, not on an expressly partisan basis. Now, of course, in nonpartisan states, nonpartisan election states, you'll have kind of for lack of a better, like dog whistles of what party a person is in. Like their ad might say something like conservative values or progressive reform or something like that, but they won't call themselves Republicans or Democrats when they're on the ballot. So it's not totally insulated from partisan politics, but there's an effort to have it be that way. And then Michigan is all out of its own. In Michigan, there's a partisan party primary to become a candidate for the judgeship, and then somehow they are able to divorce that from the ultimate election, which is nonpartisan. I don't know how Michigan pulls that off, but they seem to have done it for a while. Then I would have the 2 states, South Carolina and Virginia, which I would label the founding era Whig Republican model. Those of you who've done political science work, you know that the Whigs were big on legislative supremacy. That was the thinking that dominated in the Federalists' side of the debate in the Constitutional Convention. And at that time, a majority of states had the same model or a similar model to what we have in South Carolina and Virginia, which is legislative election of the judiciary, or legislative appointment of the judiciary, depending on how you want to denote that. The key difference today is that both Virginia and South Carolina have elements of the 4th model, which what's the name I'm giving it? I give that the name everybody else gives it, the Missouri model. But one feature of that 4th model, which I'll get into in a second, is that there is some effort on the front end to ensure judicial competence through either a merit selection committee or a governor's nominating commission, something like that, to make sure that you don't just have any sort of random person becoming a candidate for a judge. So South Carolina and Virginia both have some version of that. Our model is different from Virginia's in ways that I'm sure Stephanie will get into. But the main aspect of it is legislative election of the judiciary. The key difference in the electoral portion of it between Virginia and South Carolina is South Carolina's elections are majority of the entire legislature, and Virginia's elections are a majority of each house. So that creates some differences that become important in some of the debates that Stephanie's going to get into, I think. And then the 4th model, which encompasses 21 states and the District of Columbia, is what is generally called the Missouri Plan or the Missouri model because it started there. And the Missouri model involves usually a nominating commission or some sort of merit selection commission that determines the candidates for judgeships, and then the candidates are then typically appointed by the chief executive, the governor of the state. But then this is what makes it unique, is every so often a judge has to sit for a retention election, which is an up or down vote on whether the judge gets to remain a judge. No opponent, just an up or down vote on whether the judge gets to retain their position. So each of these has certain features and is trying to pursue certain goals. I'll talk more about that later if I'm asked to, but those are the 4 main models of appointing judges and retaining them among the states.
Well, I mean, what do you think are the most important considerations in designing the sort of ideal judicial selection process?
Yeah, ideal. Probably that's a pipe dream, but the way I think through this area is that all judicial selection systems are pursuing and or balancing four things, four considerations, four values, for lack of a better word. One of these would be competence. Competence is the ability of the person who assumes the judgeship to do the job of judging, to be prepared to do that job. So when we see this value being advanced, we look for things like age and experience requirements, law licensure requirements, which, by the way, are not universal. The judge in my hometown when I was growing up owned a junkyard. He didn't even have a high school diploma. So this is something that gets added in as we want more competence. Some suggest that higher salaries are a way of ensuring judicial competence. Our Chief Justice of the United States has made this argument in the past. And then use of an external judicial nominating commission is one way in which we might see competence being pursued. Impartiality is the second value. This one made it to the Supreme Court in Caperton versus Massey Energy in recent years. So impartiality best is described, and it's related to the third value, which is independence, but those are two different things. I know this conference is about independence. I want to give that its own separate sphere of respect, but they are related to each other. So impartiality would be ruling the same way regardless of who is in front of you, right? Or regardless of what your own political views are, or what your own religious views are, your personal preferences, et cetera, et cetera, et cetera, right? We expect judges, as near as possible, or as near as practicable, to be impartial in their rulings, to rule based on the law and not matters that are external to the law. So how do we secure that? That's difficult, but some have said that appointment as opposed to election is a better way to secure impartiality because there is no sort of need to appeal to the voters or need to appeal to those doing the voting. The imposition of life tenure or some sort of lengthy fixed tenure without the possibility of reappointment is a good way of ensuring impartiality because there's no, or at least according to the political science literature on this, there's less motivation for a judge to please whoever is going to keep that judge in the judge position. And then in an electoral system, we can ensure impartiality at least in part by having limitations on campaign finance, disclosure requirements, things like that, they don't necessarily will ensure it for sure, but will cut against any impartiality concerns. And then the last two values tend to push and pull on each other, and that is independence on one hand and accountability on the other hand. Neither one of these is necessarily a frivolous thing to care about. Everybody seems to care about both of these, but they care about them in different ways. So independence I would define as the separation of the judicial task from the influence of the other branches of government, right? So this is how it's different from impartiality. One might assess impartiality in a case-by-case basis. Impartiality is more about concerns internal to the judge, wanting to be reelected, wanting to advance a particular preference, wanting to advance a particular view, whereas independence is, in my view, the protection of the judiciary from the influence of the other branches of government. And so in designing a system to secure independence, one would seek to find barriers between the other branches of government and the judiciary. Accountability, on the other hand, just look for things we might look for to safeguard independence, right? So the granddaddy of them all is life tenure, right? This is the way we've designed the federal system to secure judicial independence, because once a judge is appointed, the judge is on the bench until they leave or until they expire. So that keeps any, or at least in theory, keeps any political influences from outside the judiciary from affecting the judge's work. That doesn't do anything about the judge's own internal political preferences, but it does do something about the external political pressures that might be placed. Salary protections is another thing you might look for independence. Appointment as opposed to election is one that has been advanced here. I'm not sure which way that cuts, honestly. I think you could have an independent judiciary that is elected or appointed, depending on how often the judiciary has to stand for election, but that is one that has been advanced. And then in thinking about how judges are removed, you would expect an independent judiciary to be protected from impeachment for anything other than a breach of the public trust, right? So that sort of a norm is the thing you'd look for. It might not be designed into the system, but it might be a norm that develops over time in that system. And I would say that norm exists at the federal level for judicial impeachments. It's only been done about 15 times in our history and only 8 times successfully. And every time it's been justified by a breach of the public trust. So that's the kind of norm we have federally, and you'd expect to see that in any system that safeguards judicial independence. Then accountability is the value that underlays a lot of the electoral systems, the democratic model systems, in that the value there is that the judiciary should have to answer to the public for its work. Now, one way in which, say, the federal model advances this is that the court has to ensure that people will listen to its decisions, that it safeguards its political capital, right? So accountability is what leads the U.S. Supreme Court to have doctrines like the political question doctrine or the prohibition on advisory opinions. These sorts of doctrines safeguard the political capital of the federal bench in an effort to make sure that people will actually listen to the court when it pronounces things, even if those things are things that people don't like the court saying. At the state level, due to certain populist movements that happened in the 1800s, we have a more direct accountability model, either involving reappointment elections in the Missouri plan or straight up elections in the majority of the states. So you'd expect to see election or appointment through political processes for accountability purposes, re-election or reappointment periodically through political processes, shorter durations of the judicial term. If you have a shorter duration, then you'd expect that the judges are more accountable to the public there. Contested versus uncontested elections may lead to greater accountability, although I could see an argument to the contrary. And then a functional impeachment or removal process. We have both of those in South Carolina. And that may be used to respond not only to breaches of the public trust, but to failure to perform the judicial task in a way that those who are seeking accountability might want it to be performed. I'm laying these out in a platonic way. I'm not saying that I favor one over the other or anything like that. These are the 4 considerations that generally are involved in designing judicial selection and retention systems. And a more modern addition to these in some of the recent political science literature has been diversifying the bench, and that is a new value. That value has become more and more important over the years as the vestiges of a segregated society in the prior years have made themselves clear, and so legislators in some states are wrestling with the idea of how to diversify the bench and what sort of structures might be appropriate for that. We don't have any examples of states actively pursuing this through their design of judicial mechanisms yet, but these are things we could expect to see coming forward.
Hey, Professor, you just, slogan you mentioned, it sort of stuck out at me. You said effective impeachment process, and you mentioned that only 8 federal judges have been impeached and removed. I'm thinking back, of those 8 federal judges that were removed, how many had been criminally indicted?
I couldn't tell you that off the top of my head.
What I'm getting at, I'm not trying to trick you, but the ones I always remember, like,
Nixon,
a lot of them were under indictment. I'm just wondering, do you know if any federal judge has been removed for just general bad behavior?
I wouldn't be able to tell you that off the top of my head, but I could find out pretty quick if I went back to the books again. But the vast majority of them have done something that has been construed as
criminal, right?
Abusing the trust of the office. So even if not convicted, something like accepting a bribe or making a deal on a case or something like that, And the most recent one was Walter Nixon, who was convicted of bribery before he was impeached.
And I think there was a judge from, sorry to pick on Judy, Louisiana, my second favorite state, but they had a judge and he was impeached, but he was under federal indictment. Yeah, I was just curious, like I said, I wasn't trying to shake it. I was just curious, had they has any judge been removed for just being real nasty, terrible?
There were efforts to remove judges based on supreme amounts of disagreement with their decisions, but these are some of the ones where the impeachment happened, but the judge was acquitted.
Well, that was excellent. All right, now putting you on the hot seat, student Radcliff, your note. It's a hot topic in South Carolina.
Absolutely.
So this is a tough one, so I don't want you to say anything. Nobody will hire you in South Carolina, but I'm joking. But just give us an overview of like how judges are selected in South Carolina.
Yeah, of course. So kind of building off of Professor Bauries' context a little bit, South Carolina is one of only 2 states that uses a legislative model to elect its judges. So historically, what this looked like was a joint committee of the Senate and the House of Representatives came together, appointed some candidates to then send those names to the General Assembly for election. But there weren't any statutorily expressed factors that they were supposed to be considering when they were vetting these candidates. So as long as you met general age and residency requirements, in theory, you could become a judge. This kind of drew a solid amount of public criticism to some degree. People specifically pointed out the composition of the South Carolina Supreme Court from 1973 to 2000. All were ex-General Assembly members, all 15 of them. And the majority were elected shortly after ceasing their service in the legislature. So kind of in response to this criticism of independence, in 1996, South Carolina overhauled their system to some degree, creating the Judicial Merit Selection Commission. The commission had the sole purpose of vetting candidates, which would then nominate those candidates to the General Assembly for a vote. But first, let's kind of look at the composition of the JMSC. So this changed in 2025, but all of this was what was kind of relevant from 1996 to 2025. So the composition of the JMSC, there's 10 total, 5 were appointed by Senate leadership, and 5 were appointed by the Speaker of the House. Of each group of 5, 3 were expressly required to still be General Assembly members, with the other 2 being general members of the public. So looking at the bigger picture, you end up with 6 General Assembly members on the JMSC and then 4 members of the public. So it didn't quite create the separation that maybe the public was asking for. But in terms of the process itself, whether they were running for re-election, our circuit court judges are on a 6-year term and our Supreme Court is on a 10-year term. But whether you're filing for re-election or just as a candidate filing for election in the first place, you file a notice with the JMSC first. The JMSC then forwards those candidates' names to the ABA, and their Committee on Judicial Qualifications would then conduct a preliminary evaluation of these candidates' qualifications. The ABA then sends their qualifications evaluations to the JMSC, and the JMSC would conduct a public hearing. And this time, they were given a list of non-exhaustive factors that the JMSC should consider, such as constitutional fitness, ethical fitness, professional academic ability, character, reputation, experience, and judicial temperament. The JMSC would then submit 3 names to the General Assembly for a vote. And that was kind of the general process, but it did get changed a bit in 2025.
Okay. Now, I read recently, even the Charleston papers are covering this, that apparently there's a new bill that would explain that to me. I think it's supposed to change the JMC even further. Are you familiar with that?
Yeah, are you talking about the one that's pending or the one that got passed and is effective now?
Pending.
Pending? Okay. So right now, so there was a recent reform that changed the composition of the JMSC, but in response to that reform, the public was kind of saying that that wasn't enough. There was a call for more appointments for the governor. So the current pending legislation would change the entire composition of the JMSC to be fully appointed only by the South Carolina governor. And the only requirements for the governor's appointees is 8 of those appointees must be South Carolina bar members. No more than 4 could be law enforcement members, and it explicitly bars General Assembly members from being appointed to the JMSC, including their spouse, their children, and even siblings. And they would have to wait a minimum of 2 years after ceasing their service in the General Assembly to then be eligible for appointment to the JMSC.
Do you have any idea what the prospects of that that most recent form is? I think the House passed it, I think, didn't it? Is it sitting in the Senate?
I believe it's still sitting in the Senate. Yeah. If I were to guess, I would assume it would not pass. the General Assembly seems to want to hold on to its appointments. And I think giving all of the appointments to the governor would then potentially create a different avenue of problems. As was aptly pointed out to me by Judge Anderson after class the other day, the executive branch is more often the other party in litigation. So by having the governor entirely control the appointments to the JMSC Commission, and as noted by our Supreme Court, the power of the JMSC is in its ability to favorably submit names to the General Assembly for consideration, but more importantly, its power is in its ability to exclude names from consideration. So I think in allowing all the appointments to be done by the executive branch maybe opens up a different door of issues that we would also have to address.
Yeah, it's funny, there's a state representative in Charleston who I'm very fond of. I won't mention her name, but she said recently, she said, if the governor appoints all members of the JMC, then the governor appoints judges. That's how strongly they feel about it. I'm not sure that's really the case, but do you have any thought? I mean, is the JMC that important?
Yeah, absolutely. I think the JMSC is super important, and I think to the extent that a lot of the recent reform addressed the composition of the JMSC, I think the General Assembly acknowledges how powerful the JMSC is and like its ability to exclude candidates.
It'll be interesting to see what the Senate does. I know there's a lot of, seems like there's a movement to pass that bill, but
Yeah.
well, let me ask you another question. So even if the JMC has changed, isn't there an argument that like members of the General Assembly who have a great deal of respect for the public service, you know, some of them are lawyers, but if you're a lawyer legislator and you're in front of, say, a circuit judge and that circuit judge's term ends in 2 years, what about a proposal that would require that member, that legislator, to agree not to vote on that judge's reelection, say, within the previous 2 years? Because that was always my fear. Now that I'm in private practice and I do some work in state court, my always fear is I was against a lawyer legislator and you're a circuit judge and maybe you're up for reelection and that litigant, you know, has some power over you. They could vote against you. They could vote, you know. What about making like the lawyer legislators for a certain period? Like if I appeared in front of, you know, a certain judge, within 2 years of that, they just have to agree not to participate in that particular judge's reelection. Is there any thought about that?
I think that could definitely be an avenue to potentially address this. I think there's probably a lot of public sentiment that would even want to go even further and have lawyer legislators recuse themselves entirely from the election process of the judges. I think that kind of runs into a different issue of you're not able to properly utilize these lawyer legislators' experience who know so much about this and, you know, have a lot of good things to contribute about the election of judges. But I think potentially putting, you know, a timeline on that recusal would potentially make sense, like only around, you know, contested issues. I think you could also maybe address this on the flip side, in the courtroom rather than in the election process itself. And I know Professor Black was talking about recusal a lot earlier, and I think we could maybe follow Chief Justice Kittredge's recent magistrate order as a potential guideline. So in South Carolina, the district senator recommends a magistrate judge to the governor for appointment. So Chief Justice Kittredge outlined kind of a process of recusal for when that senator is appearing before a magistrate that they will very soon have the power to recommend for reappointment, that perhaps when they're hearing contested matters, then they must recuse, if it's a general preliminary matter.
So the magistrate will recuse or the lawyer legislator, or the magistrate will recuse?
The magistrate would recuse and then pass that case along to a different magistrate.
Okay, but what do you do, like if you're in circuit court where if the circuit judge recuses, I mean, you know, the other circuit judges in the same boat, they're elected by the General Assembly. Now, granted, I guess the term, you know, their tenure in that particular term could be different, but isn't sort of the problem is, I'm not suggesting there's a problem, but some people think there is, that, you know, if you're in front of a circuit judge and on the other side you have a member of the General Assembly, that maybe that judge would naturally feel some pressure. And it seems like if one circuit judge recuse themselves, another circuit judge can have the same problem.
Yeah, absolutely. And I feel like that one's a little bit of a tough one to some degree. It's a little bit of a tough one to some degree because this litigant is, if you're facing a lawyer legislator and you know they have the power to then later reelect that judge, what remedy does that litigant have if they believe that there's bias against them or they believe that this isn't quite impartial? However, I think with the composition, with 46% of the senators in 2025 were licensed attorneys, and then 27% of the House of Representatives were licensed attorneys, in theory, you know, that's one vote of a total of 170, so hopefully, to some degree, that outweighs. I think it becomes more of an issue when it's a lawyer who's on the JMSC and appearing before a judge in a contested matter, and their election is coming up, say, in the next 1 to 2 years, then you're, instead of one of 170, you're now one of 12 that can potentially bar that name from going forward.
That's a great point. That goes back to your earlier point, how important the JMSC really is. I mean,
Right.
because if they can weed somebody out and they never even get to the floor, that, you know, that is powerful. That's God, what a great topic. Did you plan this around this, or did you just
I started.
It's-
No, I started this kind of interested in South Carolina's judicial system because it was only like 2 of the whole U.S. that does this. And then after talking with my professor advisor a lot on this topic, we kind of brought in recusal and a lot of the recent reform. And I do think maybe we should go into kind of how the JMSC changed in the recent reform, because I feel like the legislature needs a little bit of credit there, because I think to some degree.
Can you tell us about that? I was going to ask you that. What were the reforms last year that passed?
Yeah, so they seem to focus mostly on increasing transparency and independence. I personally think the transparency aspect of it is the most impactful, but I think the independence aspect with the JMSC composition got more attention. So compared to the original model, we had 10 people, all of which appointed by General Assembly leadership. Now we have 12 people with that appointments kind of split. We've got 4 appointments by the governor, 4 appointments by Senate leadership, and then 4 appointments by House leadership. The governor's only requirements that they must be members of the bar. And then for the House and the Senate, of each of their 4, 3 are still required to be General Assembly members. So again, looking at the total composition, you have half of the JMSC are still General Assembly members, and 8 out of the 12 are still decided by the General Assembly. It did add some term limits, which I think is helpful. So now they can serve no more than 2 consecutive terms. So I think that kind of reduces the risk of a JMSC member functioning as a gatekeeper to the judiciary. And then added a little bit of a qualification that if a judicial candidate comes before you and that candidate happens to be a JMSC family member, the JMSC member must resign. And I think that also potentially goes a long way to increasing impartiality. But I think one of the more impactful portions of the reform was in terms of transparency in the election process itself. So one new kind of addition with the reform was these candidates, when they come before the JMSC, must now disclose any and all sanctions, including private reprimands, which is notable because as the general public, we've never had access to a judge's private reprimands. They're private. But now they must disclose that to the JMSC. And kind of along those lines, before, if a candidate were to withdraw from the JMSC, all of the materials regarding that candidate's investigations were to be destroyed. Whereas now, anyone can request a copy of the testimony, the documents submitted at the hearing, and any findings of fact that the JMSC makes during that. So I think that also goes towards accountability. And then importantly, it added a midpoint review system for judges. So now when the JMSC knows that a judge is reaching the midpoint in their career, whether it's 3 years for the circuit court judges or 5 for the Supreme Court, they forward those names to the ABA, who then conducts kind of a midpoint review system of how the judge is doing in their term. And I think that kind of provides a little bit more documentation for later when the JMSC either finds that candidate qualified or unqualified. Now there's a paper trail of a review system that happened, years prior by an independent party. So there's a little bit more support for the JMSC's findings.
Stephanie, that's a great point. I wasn't aware of that. So that midpoint review, is that shared with the judge, the judge itself?
Yeah, so the well, I guess it would be shared with them when they're evaluated at the JMSC, but the ABA reports those findings to the Chief Justice, who keeps that on hand and then later sends that back to the JMSC when the judge is up for vetting.
I mean, what I'm saying is just, what I'm getting at is, say if it was a young judge perhaps, and maybe they got off to a rocky start, and 3 years in, they got evaluated by the APA. I mean, could Justice Kittredge like share that with the judge, and maybe just as an opportunity for them to improve? That seems like a great idea if they could.
Yeah, I can't imagine why not, especially since this material will become available to the public as soon as they're up for re-election anyways. So I want to say that they should be able to request it, but the statute didn't specifically say it. And since it's so new, I'm not sure that anyone has undergone that midpoint review yet.
It's interesting. That thing was fascinating.
Let me note one thing. The review that you're talking about, I think, is done by the South Carolina Bar, and not the American Bar Association.
Oh, I'm
God
sorry,
bless us. No, the work that the ABA does is in and of itself enough of a load, but I can't imagine delving into all the state bar elections all over the country. But it is critically important. I think these bar committees across the country who do this kind of work is critically important. No matter what kind of system you have, whether it's an elected system or whether it's an appointed system through a process like here in South Carolina.
I apologize. Let me correct myself. Every time I mentioned the ABA, I meant the South Carolina Bar Association. It just gets confusing with the acronyms, but.
I think that's a great, I think it could just help a younger judge, or,
Absolutely.
it seems like it, nice course correct. We all make mistakes, and it's funny, for y'all don't know, I grew up in South Carolina traditionally. Once a judge was elected to the General Assembly, basically, even though they have 6-year terms, 10 years for the Supreme Court, it's basically a lifetime appointment. No one really ever challenged them. I grew up in Aiken County. We had this just tyrant of a judge. I was just a kid in high school. I heard about him. He's like just terrorized litigants. And for some reason, that guy, amazingly, for 40 some odd years, and I never appeared in front of him, but thankfully, he managed to stay in office, and but now, getting more and more, we've had in the last decade, we have 2 judges in Charleston, 2 circuit judges, that followed back to back, and they were both challenged and they were both defeated. So, and that used to never happen, and that's just 2 in my hometown. I know there was one in Florence, and maybe a little bit further back, but you're seeing them challenged more and more. And interestingly enough, all 3 never made it out of the JMC. The joint, so they didn't get defeated on the floor, but they went to the Joint Merit Selection Commission, and they never made it out. So they were sort of killed in committee. But that was awesome, Stephanie. That was a very timely. I appreciate it so much. And last but not least, we're going to talk about the World Justice. Tell us about that, Judy. Now, I have to admit, what is the World Justice Project?
So I think what I'm being asked to do is to kind of step back and give a bigger picture on judicial independence across the globe. And that's why the World Justice Project, I think, is a good resource for people in this room. And what I'd call it is just an extraordinary, or a conveyor of an extraordinarily reliable assessment of the rule of law, the status of the rule of law across the globe, if not the most reliable assessment of the rule of law. And of course, we all know that judicial independence is critical to the rule of law. We've been hearing that from all of our keynotes and other panels throughout the day. And so what the World Justice Project does is annually it produces a rule of law index, which is based on about 215,000 household surveys and input from about 4,100 legal experts from around the world who look at 8 factors that make up the rule of law, if you will, or contribute to a strong rule of law, 44 sub-factors, and we delve into this through about 550 different questions. And we do this in 143 countries around the world. And what we do is give each country a rating each year on how they're doing on all these factors. And of course, the justice factors, judicial independence, is critically important to that overall rating. Now, you heard Dean Hubbard earlier in the day, and he showed for you some of the data that comes out of the World Justice Project with regard to how different countries and the U.S. is doing. And I would suggest to you that I am always the eternal optimist, there are bright lights of hope, but overall there is a significant decline in the rule of law. There is a recession going on as we speak, and that in great part is contributed to by the lack of judicial independence that we're seeing. And what we all know is that when there's broad declines, like he referenced earlier, in criminal and civil justice, that deterioration after it starts happening, it accelerates year after year. And then it can't stop. And hopefully there is not a point of no return, but we are dangerously on that brink. And I would suggest to you that dismantling happens very quickly. Like I said, it accelerates, but rebuilding all of those elements of the rule of law can take lifetimes. So it's important for all of us as lawyers, and I would even more so urge law students that you begin your careers thinking about how you individually, whether you belong to an organization and are active in an organization or otherwise, can contribute to strengthening the rule of law and strengthening judicial independence. The U.S. was ranked 27th out of 143 countries in the index on the rule of law this past year.
Does that include federal and state judges, or is it an entire?
This is the rule of law index, overall rule of law. 20th out of 31 countries in the EU, in the EFTA, the trade area, and North America, and 27th out of the 51 highest high-income countries in the world. And so what we know is that we are at great risk of having the integrity of our checks and balances in our systems, which of course is in part driven by a weakening of judicial independence, is greatly at risk. And so what we need to do is really get a sense of how we can go forward and strengthen the rule of law by strengthening judicial independence. And judicial independence in the index is looked at, and it's an extraordinarily fun interactive tool that we have on the World Justice Project website to look at by country. You can look at everything that happens in a country and how it's assessed, or you can look at across countries, across regions, and see how different regions of the world are doing in terms of factors like independence of the judiciary, absence of corruption, open government, constraints on government power, fundamental rights, order and security, the environment, civil rights and social justice, and more. And what we know that within judicial independence, we look at judicial powers, appointment, tenure, career progressions, accountability that we've heard so much about today, and integrity. And most importantly, we look at perceptions, because the index is based on perceptions. The index is based on people's experience, their real life experience with the rule of law. We look at trust and confidence in the judicial system in countries. And that tells you so much about how people believe. Their perceptions are critical to our understanding about judicial independence, because we all know that the courts don't have that power of the purse. They stand alone in so many ways. But what they do have is their greatest asset, is the trust and confidence of the people for whom they serve.
So, like, what were the top 5 countries?
So if you look at judicial independence factors, Ireland, Luxembourg, Estonia, Denmark. We know that countries with government powers have that there's an effective control over check on government powers are limited. Denmark, Norway, Finland. Civil justice is free of improper government influence. Norway, Denmark, Ireland. Criminal justice, the same. Denmark, Finland, Canada. And so what you see, and you see the same thing in the overall scores for the Rule of Law Index each year, is that despite an 8-year decline in over 60% of the countries in our world on rule of law, what we're seeing is that there are some countries that are remaining strong and even getting stronger. And some coming up in their rank gradually and slowly, but they're coming up. So there are moments, what I'd say, of optimism or hope for all of us to be held on to. And I think it's incumbent upon us in the United States, at this particular moment to make sure that we don't think that we do everything right, that we don't think that we can't learn from others across the globe, and that we look outside and see what some of these countries are doing so that we can care and protect and take the step necessary to protect our judicial independence at home.
Now, another curious question, please, members of the audience, feel free to jump in here, but did the global judicial independence ratings correspond somewhat to the wealth or education of the country? It sounds like some of the ones you mentioned, as I suspected, are wealthy European countries.
Yeah, you know, we haven't tied directly to judicial independence, but I can tell you there is a strong correlation. We're not saying causation, but there's a strong correlation. When you have, where you have strong rule of law, you have better health. Infant mortality rates are lower, maternal health is better. Where you have strong rule of law, you have higher education levels. Where you have strong rule of law, you have greater GDP, higher GDP. And where you have strong rule of law, you have peace, sustained peace.
Probably less crime too, maybe?
I don't know at the crime factor, but I'll take a look at it and let you know.
Well, tell us a little bit about, you're a New Orleans native. Tell us a little bit about how Louisiana selects judges. My understanding it is public elections. I don't recall if it's partisan or not, but I do know that they're elected by the public, correct?
Right. So I want you all to feel better about South Carolina right now after you listen to what I have to say. And I'll talk about some strengths that we should pull from the public election process. But in Louisiana, all of our judges, all the way up, bottom to top, are elected by popular vote. They are partisan elections. And what that means is that they're not only partisan, but that appears on the ballot, the party with which you're affiliated. And in 2026, there was just a piece of, 2025, there was a piece of legislation that got passed through that now says that we used to have open primaries, but the party of the individual was noted. As of 2026, our Louisiana Supreme Court is going to be like our U.S. Senators election and several other offices, our education boards, and it's going to be a closed primary election for members of the Supreme Court. And in addition, in Louisiana, our Supreme Court members are not elected statewide, they're elected by their district. So there's a lot of issues there, of course. The weaknesses we all know. Judge Bauries described them beautifully. I won't dwell on them, but certainly the influences of campaign financing, misinformation, groups that are coming in, special interest groups who are influencing the elections. There are tremendous amounts of work to be done because of the system that we have. But what I also tell you is that there's often low voter turnout on judicial elections, even though it's been a privilege given to the people. And driving that up is always a challenge in the state. But there's one piece of it, and you touched on this at the very end in terms of values, that I think can't be denied. I'm born and raised in New Orleans, and our courts have always, for so many years, centuries, decades, have been all white males on the judiciary. And there have been, in the last 2 decades, 3, extraordinary, courageous women, and I would suggest to you, extraordinary, courageous black women who have stepped up to vote, to serve. And my Orleans Parish District Court is not only, it was all female a few years ago, or female and persons of color. It is now majority female, and the remainder are men of color. And we are a parish, and that's the whole city, is the parish. We are a parish that is, right now it's dropped some, but it's majority black. And if that doesn't slap you in the face in terms of what it does in empowering people with trust and confidence in the judicial system, nothing else will. And I know that there are people in my state, and oftentimes, most of the times they're wrong, but they're very critical of that bench, particularly the trial bench. They could have voiced those same criticisms of the benches as that they existed for many years as well. So if I had to import something from the electoral process into the merit selection process, which hopefully maybe my state will embrace one day, it would be that they understand the value and the drive that will happen with trust and confidence when in fact the bench looks like the people whom they serve.
One last question, we'll wrap it up. Is it possible in rare circumstances that a judge can have too much independence?
You know, my belief about the criticality of judicial independence is that it's sort of like due process or oxygen. You don't know what you're missing until it's not in the room anymore, until it's not how you're living. And I think that is the same with judicial independence. I think we have controls in place that we can use, and they can get better in terms of reining in any bad actors, if you will. But I think our founders, as we heard today from our keynote, understood why judicial independence was so important. I don't know if you've been following the news of late, but just this very week, the federal courts, the Committee on Judicial Advisory Opinions for the federal courts, issued a new guidance with regard to judges being able to speak out on attacks on judges themselves. The ABA just issued opinion, I think it's numbered 512, which talks about what judges need to do within their own chambers in their administrative and supervisory duties to uphold the integrity of the court. So I think if there is to be judicial independence, it is up to us to make sure, judges and lawyers alike, that we in fact hold it to its highest standards and make sure that we're doing our part in our role to assure that it can be maintained, because it's what the most important thing that the judiciary holds, and they hold it in trust for our entire citizenry.
She didn't take my bait, but that was a great answer. Does anybody have any questions? This was fantastic. All three of y'all, I learned a lot. And yes, sir. No, please.
And this is maybe more for Professor Bauries. And I may have missed it, I apologize if I have, but has there been any systemic attempt to look at, either attorney satisfaction writ large under different systems, or whether the bar-sponsored evaluations come out significantly differently under the four different models that we could say, gee, one seems to, and maybe this doesn't mean it's the best system, but it would at least be leaving attorneys happier, leaving the organized bar happier.
I don't know about the bar writ large, but I did read a study recently, a political science study in judicature, that studied the opinions of judges who are serving in each system about their own independence and about their own accountability. And the study authors, and I love it when a study like this gets published, it's called a null result. And they don't get published that often, especially in the sciences, but social science is a little bit more tolerant of them. But the study authors expected there to be some differences in judicial senses of their own independence based on the different modes of selection, and they could not find a significant difference that depended on the mode of selection. So it seems like the judges in each system are, I don't know if the word happy is the right word for it, but feel like their independence is protected at the same rates. The ones who feel like it isn't protected enough can't be predicted based on what system they're in. And the ones who think that they're protected just fine, they can't be predicted based on what system they're in either. Now, of course, when you're studying the United States of America, you only have 50 observations, right? So this doesn't tell us a lot necessarily systemically about what we might expect in a larger group of judicial systems, but it does tell us something, and it's surprising, it's surprising that there wasn't an effect there.
And I just add that the attacks on judges are happening whether they're elected or whether they're appointed. And so I think it's really incumbent upon not only the organized bar, but individual lawyers to stand up for them when they're being attacked. And then when I say stand up, it may be standing up at your kitchen table when somebody in your family is voicing something about them. It may be standing up in a closed door office in your own law firm when one of your partners is saying something, whether in front of a client, which often happens, right? And saying things about a judge personally that didn't rule in his or her favor, or it's in a meeting in the civic space. But what we have to do is not let those, they're duty-bound opportunities, if you will, go by without really speaking up and defending the independence of the judiciary.
My question is, South Carolina, is there any judicial recommendation for magistrate judges to be lawyers?
I'm not sure I understood the question.
Yes, ma'am, we're having a little, I apologize, we're having a little trouble hearing you. If you could speak up, we'd love to.
Is there any recommendation to require magistrate judges to be lawyers?
Magistrate judges to be lawyers. Magistrate judges to be lawyers.
Okay, yeah. I mean,
those of you not familiar, you don't have to be a lawyer to be a magistrate judge in South Carolina. So the question is, should that be the case?
I think I'm the only practicing lawyer in South Carolina on this panel, and I think absolutely that's a great question. And I think Justice Hall may mention, I think Chief Justice Kittredge has made that proposal. So yeah, I mean it's even in magistrate court, I mean they can handle civil cases up to $7,500. They set bonds. I mean, it really is an important position, and I think they absolutely. I think we'd all four would agree they absolutely should be lawyers, and I hope Justice Kittredge gets that done. Yes, sir.
There's somebody behind you.
Yes, well, I thank y'all for the panel. I really appreciate it, and Steph, thanks for the article. It was a great article and really interesting topic. My question was mainly for Ms. Martinez. I was just curious why they chose those specific offices to close the primaries. So just certain judges have closed primaries, and what was their intended effect with this policy change?
I don't know the answer to that, but I know the coverage of the change is for the Supreme Court, the U.S. Senators, members of the House of Representatives, the Bessie Board, which is our education board, and there may be one other. So I'm not sure. And I've actually reached out and tried to get some explanation on that. But it is an interesting move, and I don't know even whether implementation will go smoothly in terms of this first time around for the next election.
Thank you all for being here. And my question is for Professor Martinez. It's sort of a two-part question, if that's all right. My first question is, and they both pertain to your discussion of the ranking of countries and the independence of the judiciary. My first question is, does that ranking take into account the jurisdictional limits that might be on justices? So in our country, justices and the judiciary can initiate prosecutions, for example, but that's different in Brazil, different in other countries. Does that take into account the scope to which judges have discretion to act? My second question goes to, you mentioned that the ranking takes into account the public perception of the judiciary. And I'm just wondering whether there's any sort of confounding variable where countries that tend to have less political polarization overall also rank more highly in judicial independence. So those are my two questions.
So as to the first question, the WJP, the World Justice Project, recognizes that what we have is a tool. And it is a tool to be used in conjunction with other examinations. I should say it is used by governments, academics, the press, major corporations, major funding institutions who go all over the world and want to see whether their investments that they're in are trending in a certain way, in a country that's trending in a certain way, or whether they should go into a country, as a matter of fact. And what we really are trying to do is we recognize that there are cultural differences in countries, to your point, and try to bear with that as we go through and do the rankings. So yes, there is that unknown out there. As to your second question on polarization within the country versus the scores or the rankings they get on judicial independence, I've not seen a direct correlation on that. And I'm not sure, if William may know, I'm not sure we have undertaken one at all. No. But it's a great question. I'll bring it back to the economists and the data scientists and see what we can find out. Yeah. Right. William was repeating what I had said earlier. 550 questions are asked. So I will have to go and parse and see if we can figure that out for you.
Yes, sir.
Well, thank you so much. I found the panel fascinating because I'm from the UK, so there's lots of points of comparison. I just wanted to ask the panel to maybe speak a little bit more about impartiality, because in English administrative law, we have the rule against bias, which then has various sub-rules. So I just wondered how that operated in your context. Thank you.
Well, I would say, and thanks for the question. I enjoyed your talk last night, by the way. The notion that there's a rule of impartiality is probably contestable, even that in the United States. There's an expectation, right? And we have a baseline due process expectation of unbiased justice, which has led to one Supreme Court case recently, the one that I mentioned, Caperton versus Massey Energy. And the reason that case was ruled to result in unconstitutional bias was because one of the parties that was before the judge in that case had donated millions of dollars to the judge's campaign. So a very clear danger of corruption or bias in that case, right? So other aspects of bias are mitigated in our system through judicial management of the judiciary itself, the sort of ethics rules that judges follow, which can be toothy or not toothy depending on what system you're in, or the various political bodies that govern the judiciary. If they conclude that a judge is intolerably biased, then it might lead to an impeachment proceeding. But otherwise, it really is a norm and an expectation more than a rule, right? And that sounds kind of weird in a system that prides ourselves so much on having the rule of law and being a strong rule of law jurisdiction. But it is really something that is up to the judges to kind of feel deeply, rather than a rule that can be applied by an external actor.
Yeah, if I can also jump in here, kind of in my research, I focused a lot on the Judicial Code of Conduct, which puts the onus on judges to avoid the appearance of impartiality to the greatest extent possible. But in doing that, to some degree, it doesn't give them a set guidelines of, all the ways that something could be considered impartiality. And kind of the solution for the judge is to then recuse themselves from the case where they might have an appearance of impartiality issue. But like Professor Black was kind of talking about earlier, recusal motions are largely unreviewed and the judge decides on their own recusal. So even if a litigant, to some degree feels that there's bias or this impartiality isn't being honored, they can file this motion with the judge, but the judge ultimately decides whether or not they're biased. And I think it's kind of an impossible position in terms of viewing your own bias and ruling on that. Empirical scientists have kind of referred to this as the bias blind spot, where you view your own personal connections to something as a useful source of information, but other people view that as a source of bias. So it kind of creates this circular issue to some degree.
And if I can just add, I'm not a member of the Standing Committee on Federal Judiciary, and it's been many, many years since I've been involved in it. But I can tell you that that's why I would argue that there is no more important role than the role that committee plays, the ABA, Standing Committee on Federal Judiciary, because it looks and narrowly focuses on only 3 factors: integrity, competence, and judicial temperament. And within that, the notion of impartiality sometimes is something that is an issue is brought forth because of those confidential interviews that are undertaken, 40 to 60 to 80 on a particular nominee. And those are undertaken to find out from the bench and bar who know that person who's the nominee well, whether in fact there will be impartiality. So just think about, if we adhere to and stick to integrity, competence, and judicial temperament, how we can help strengthen on an ongoing basis judicial independence in this country.
Yes, sir.
As we know, there's an ongoing discussion about what is the optimal way to select judges. And I think this is for you, Professor Bauries, but anybody can take it. We know that in the overwhelming majority of states, we have two methods of judicial selection. We have one method for choosing federal judges, and we have a different method in almost every state for choosing state judges. To what extent do we know, or is it even feasible to research, whether the political culture of a state affects the kinds of judges who wind up on the bench in that state, whether in federal or state court? To what extent that political culture might affect, for example, impartiality, competence, things of that sort. I don't know if any such study is even feasible, but I'm just wondering if we know anything about that.
Well, I could just tell you anecdotally, like, if your question is, does an individual state's politics play a role in judicial selection? They absolutely did. When I was a young guy, I remember the Supreme Court justices in Texas, Alabama, Florida, Georgia. They were, overwhelmingly Democrat. And in the last 20 years, I'm not saying this is a good thing or bad thing, just purely an observation. But those states have moved to the right, and I think Texas, and I know Texas and Alabama and Louisiana, they're popularly elected. And I think every member of the Texas Supreme Court, it ran as Republican. Every member now of the Louisiana Supreme Court, I know Alabama, all 5 of them were elected as Republicans. Florida, gubernatorial appointment, but you had Governor Bush and then Governor DeSantis. Florida Supreme Court used to be really, if you look back to the Bush v. Gore election in 2000, that was considered to be a quite liberal state Supreme Court, and Governor Bush and Governor DeSantis sort of made it their mission to change it. So, and I think the same thing if you look at states like Massachusetts, California, Vermont, New Hampshire, New York. The states are they're more democratic, and their judiciary reflects that. I think we would all it would be foolish to deny that. I'm not saying it's a good thing or a bad thing, but that's a fact.
I guess I'm trying to figure out, do we know, or can we know? Thanks. Whether there is what kind of correlation there is between the federal courts and the state courts in whether it's Texas or California, Massachusetts, South Carolina, whatever. I don't know the answer to that. I'm just wondering if looking at that might give us some insights into the discussion about what is the best way to select judges in general.
They'll still be a tracking, because if you look at those states, at least federal district judges, they're largely, they're appointed by the president, but they're recommended by both the U.S. senators, and all the states I mentioned have 2 Republican senators. All the Democratic states I mentioned all have Democratic senators. So some, you'd be surprised. There's probably more correlation, I suspect, than you think. But I'll prefer a professor if he has any statistics.
I don't have statistics at the ready. There is a very, very large body of political science scholarship studying, falls under the label the attitudinal model, studying judicial decision-making along political lines. And the vast majority of those studies have been done on federal courts. And and you're hitting on the problem that it's very difficult to code for impartiality or code for bias or code for respect for the rule of law, right? And any empirical study has to code for something, right? You can't run it through an empirical tool until you code it and make numbers out of it. So what the political scientists have generally defaulted to is coding case outcomes and saying, well, this would be the Republican outcome and this would be the Democratic outcome, and here's what we would expect based on the party identification of the federal judge, and look at here, the Democratic judges are voting more in favor of what we considered to be the Democratic outcome, and the Republican judges are voting more in favor of the Republican outcome. One of the critiques I have for that is that most decisions don't have a political valence. Most judicial matters are non-political in nature, and the best evidence for this is we have 3 judge courts at the appellate level in the United States federal courts, and something north of 90% of the decisions are 3-0, and we have mixtures of political identification in every circuit in the country. You wouldn't expect that if politics was driving a lot of the judging. Now, is it driving some of the judging on these politically salient cases? Probably. So then the question is, to what extent do we expect people to separate themselves from their cognitive frameworks when they come into the bench? And to what extent is that even possible? And to what extent do those cognitive frameworks get driven by either political or religious or other sort of values-based systems? And that's really, really difficult to measure. Now, as to the state court scholarship, it's mostly been topical. So there's been studies on school funding litigation, which is a really big area in state Supreme Court jurisprudence. Studies on school funding litigation haven't found an effect or a strong effect based on the political identification of the judiciary. And that's notable, too, because those are very politically salient cases. The case in Kentucky led to a $600 million increase in taxes. So if you think about politically salient cases, those are them. And the political scientists haven't identified a strong effect based on political identification of the court in those areas. So we have limited data on the state courts, and we have no data comparing federal courts and state courts on those matters that I am aware of today. That's something that probably would have come across my desk by now, but I could have missed it. But you've hit on the exact problem, which is it's very difficult to code bias or lack of bias.
So much for being here today. Thank you, Rhett, for moderating. Steph, I appreciate your bravery and stepping on this impressive panel. Professor Bauries, thank you. And Judy, thank you for everything. I've known Judy my whole life, so this has been a real moment of personal pleasure for me to get to do this with her and see her shine so much. So thank you, guys. We're going to take a 10, 15-minute break. We'll be back at 3:30 for the next portion.
But then, like you said,